Welcome everyone to the Federal Bar Association Key 10 sections, the rounds, FCA news with Tejinder Singh. The rounds is Tejinder's regular analysis of noteworthy FCA cases. I'm Scott Oswald. I am chair of the Key 10 section with Tejinder Singh, who is a partner at Sparacino PLLC. Tejinder, hello.
Hey, Scott. Great to be with you.
So today we begin with a new case out of the Fourth Circuit, a 2-1 decision in U.S. ex rel Gugenheim versus Meridian Senior Living. This case deals with the impact of regulatory ambiguity on scienter, but its timing in light of the court's upcoming en banc review in Sheldon versus Allergan Sales, which we dealt with in our last episode, is interesting, isn't it?
Oh, definitely. So this is a case where the Fourth Circuit reaches the conclusion similar to what the court held in the now vacated opinion in Sheldon, that regulatory ambiguity defeats scienter. And this case is up at summary judgment. And I noticed that the panel in this case includes Judge Wilkinson, who was in the majority of the vacated opinion in Sheldon. And so it looks like he's trying to get his licks in on this issue, even as the full court is reconsidering the wisdom of his prior decision in a case that's going to be argued again in September. So it's interesting. The Fourth Circuit seems to be sort of doubling down, but maybe not really, on the idea that when you have regulatory ambiguity, you can't have scienter. But that's going to be obviously clarified to a much greater degree when the court takes the issue up again in just a couple months.
So is it possible that the court sitting en banc could overturn Sheldon, but still this decision could stand? Is that possible?
Anything is possible. In this case, the Gugenheim case, what the panel majority says is that the evidence of scienter is particularly weak. They say here the relator is depending only on the asserted clarity of the relevant regulations and on the defendant's failure to seek further clarification from the government about what the regulations require. And so it's different from a case where, for example, the plaintiff has evidence that the defendant subjectively believes that he's doing the wrong thing, but continues anyway. There's no such evidence discussed in this case. And so you can see a potential path forward, even if the en banc court reaches a different result than the panel did in Sheldon. That said, I would assume that there's going to be a lot of overlap in the discussion, and that the en banc decision, being by the full court, will obviously take precedence going forward about what the rule is.
Now we turn to United States ex rel Vermont National Telephone Company versus Northstar Wireless, two big companies going mano a mano here, Tejinder, in the DC circuit. There were kind of two issues here. The first was the government action bar, which we haven't dealt with before, at 31 U.S.C. 3730E3. Tell us what the government action bar is.
The government action bar prohibits qui tam actions that are based on the facts that are being asserted in a civil suit or a civil administrative money penalty proceeding where the government's a party. And the idea is, if the government's already going after the money, relators can jump in and try to go after the same money. In this case, the allegations involve the spectrum auctions that the FCC holds. So when wireless companies want to put things out over the airwaves, they have to buy the right to use those airwaves from the FCC. It all happens in an auction process. And here, a couple of bidders said that they were very small businesses, and as a result, were able to get discounts on their auction prices, basically credits that knocked about 25% off the price they paid. A significant amount, about $3 billion worth of credit they were able to pick up. And the allegation is, well, those folks weren't really small businesses. They were just fronts for Dish Network, which is a humongous business. And what the defendants said is, they said, look, there's this whole administrative process by which the FCC can figure those things out, and in fact did figure it out and retroactively took the credits away after we had submitted our winning bids. And so there's a civil penalty proceeding that bars a qui tam action brought by our competitors here. And the DC Circuit says no. It says there is an administrative proceeding, but it's not a money penalty proceeding. It's part of the auction process and distinct from a proceeding for monetary penalties.
This case also dealt with materiality, specifically at what point the court kind of uses to determine materiality analysis in a case. Tell us more about this kind of timing issue and materiality.
Sure. So in this case, there's a two-step process for the auction. The first step is where these businesses said, hey, we're very small businesses, so we should be eligible to get these credits. And then there's a second step where all the eligible bidders submit these sort of long form applications. Those get reviewed, and the winning bidders' applications can actually be challenged. And so part of what the defendants said here is they said, look, eventually, this was all sorted out. There's no argument that we made material misrepresentations by making misrepresentations on the front end about our very small business status. And the DC Circuit says, no, actually, these determinations, whether you are truthful in the beginning, bear on whether you're even eligible to bid. And we think that at the pleading stage, that's enough to show that these representations are material to whether the government would give you these credits, to whether it would allow you to bid and participate in the process at all. And so even though farther down the line, these representations get scrutinized in greater detail and your representations were in fact rejected down the line, they were material at the point they were made, which is the relevant point in time.
So let's turn to our last case, United States ex rel USN 4U LLC versus Wolf Creek Federal Services out of the Sixth Circuit. In this case, the Sixth Circuit delves into what's necessary to meet the 9B pleading standard. Tell us more about this case.
Sure. So it's not just a 9B case. This case is all over everything. There's a really interesting materiality discussion. There's an interesting discussion about when estimates could be actionable falsehoods. So just to give the factual background, this company, Wolf Creek, was set up to provide facility services like renovation, carpentry, that plumbing, that sort of thing at various NASA facilities. And there was this process by which they would submit estimates of the amount of labor that it would take. And then those estimates would be approved. And then they would do the work and submit invoices that basically always corresponded to the estimates. And the relator's allegation in this case is that the estimates were systematically inflated, that they were estimating many multiples of the amount of time it would actually take, that they were saying we need plumbing services even when there was no plumbing work to be done, stuff like that. And there was scienter evidence, including a recorded conversation where they were talking about the ways that they were inflating these estimates basically to pump money out of the government for work that wasn't really being done. And the defendants say, look, these are estimates. We supply estimates. We say this is our best guess for how much this is going to take. And you can't just say that an estimate is a false thing. The court actually doesn't really get into that. And there's a concurring opinion that talks about it. It says the parties don't really debate this issue in any detail, so we're not making law about it, but this is an issue that we should have our eyes open to. And so I'd encourage everyone reading the opinion to bear that in mind, that there's this kind of lurking issue in the case. What the issue mostly turns on is even after these allegations of fraud are filed by the relator, there's no intervention from the government, and the government apparently continues to pay the contracts and doesn't take any other action. And so the defendant makes the bog standard Escobar materiality argument and say, hey, look, continued payments, actual knowledge of violations, not material. And the Sixth Circuit rejects the argument very emphatically, and it kind of ticks through all of the various justifications the defendant offers and says, no, these could be false statements and they could be material, notwithstanding that the government continued despite learning of the allegations, notwithstanding that the government didn't intervene. So I think this is a very, very strong pro-relator opinion on the materiality question. It also gets into, as you say, issues about particularity in Rule 9b. For that one, this is a case where the relator actually supplied representative examples, which I think every circuit holds is sufficient to satisfy Rule 9b. There is, of course, an ongoing debate and a circuit split about whether, in the absence of representative examples, what level of detail you need.
Well, let's turn to that issue and the Supreme Court. There's been some interesting action there, Tejinder. Tell us about it.
Sure. So I'm involved in 3 cases now. I represent the relators in all 3, twice as a petitioner and once as a respondent, where various parties are asking the Supreme Court to take up the question of what Rule 9b requires. And so we've talked about some of these cases already. They're the Bethany Hospice case from the 11th Circuit, the Owsley case from the 6th Circuit, and the Prose versus Molina Healthcare case from the 7th Circuit. And those petitions have all made their way up to the Supreme Court, and the Supreme Court called for the views of the Solicitor General. The Solicitor General filed a brief saying, this circuit split has mostly abated, nothing to see here, you don't need to take it up. On behalf of the relator in the Bethany Hospice case, which is where that brief was filed, I filed a response and said, I think the government is wrong. What was really interesting is that the defendant in the Molina Healthcare case in the 7th Circuit also filed their own supplemental brief and said, yeah, we think the government is wrong too. And so the Supreme Court is about to rule on that petition and decide whether to hear the case. As they make that decision, they now have the observations of plaintiffs, defendants, and the government about whether they should take it up.
And that's coming soon, isn't it?
Yep, that's toward the end of this month at the Supreme Court's last conference. We should have an order on that petition by the end of the month.
Tejinder, we'll be watching that. And thank you, Tejinder, and thank all of you for joining us for this edition of The Rounds with Tejinder Singh. We will see you next time.